April 2024 Employment Law Changes. Hi, I'm Laura, a virtual HR consultant for KeyHR. I am here today to present a webinar to help you understand the recent changes in employment legislation. April 2024 has seen more changes in employment law than in previous years. This webinar will give you an overview of what the changes are to the legislation effective from April, and what you need to do as an employer to ensure your business stays on the right side of these changes. What are the main areas of the legislation that have changed? This year the government has given more rights for employees to request flexible working, put tighter timescales on employers to deal with flexible working requests, given new rights for employees to take carers' leave, given greater protection from redundancy for those on maternity or adoption leave, changed how holiday calculations should be made for zero or irregular workers, increased statutory payments, flexible working requests. Previously, employees would have needed to have worked for their employer for at least 26 weeks before they can request flexible working. However, under the new regulations, this requirement is being removed. As from the 6th of April, 2024, employees will have the right to request flexible working from the first day of their job, be allowed to make 2 flexible working requests within a 12-month period instead of just 1. Employees will no longer need to provide a detailed explanation of how the proposed changes will affect their work or how they could be managed. The new regulations have also introduced changes for how employers handle flexible working requests. Previously, employers had 3 months to respond to a flexible working request. This has now been reduced to 2 months. Employers must now consult with the employee before rejecting a flexible working request. To ensure you comply with the regulations. Firstly, it is important to make sure that you have up-to-date flexible working policies that reflect the changes to the regulations. Secondly, make sure line managers are aware of the changes and how these affect flexible working requests after April 2024. Carers' leave. The Carers' Leave Act 2023 came into force on the 6th of April, 2024. The Act grants employees, who are also caregivers, the opportunity to take 1 week off annually for caregiving duties, which can be taken in full or half-day segments. All time off under carers' leave is on an unpaid basis. This time can be used to look after a family member with significant health requirements, either mental or physical, or to organize their care. Carers' leave is contingent on the caregiver's relationship with the person in need, focusing on those requiring long-term or end-of-life care. The right to take carers' leave is a legal right from the employee's first day of employment. What are the key facts an employer needs to know? Employers can ask employees to confirm their eligibility for carers' leave, but detailed evidence of the family member's condition or caregiving activities is not legally required. Employers are not permitted to deny a carer's leave request outright, although they may postpone it. This is only permissible if the absence of the employee would result in significant disruption to the organization. The Carers' Leave Act 2023 is a new piece of legislation. As a result, most businesses will not have in place a formal carers' leave policy. As an employer, it is important to get a legally compliant carers' leave policy in place as soon as possible. It is also just as important to ensure that all levels of the business are aware of the new regulations and the company carers' leave policy. Do not just disregard any requests for carers' leave. It is a legal right, and failure to give an employee carers' leave could result in you facing hefty tribunal claims. Maternity and adoption protection. Under the Protection from Redundancy Pregnancy and Family Leave Act 2023, that came into force on the 6th of April, 2024, additional protection is now given to expectant mothers, those adopting a child, those on maternity leave, those on shared parental leave. Under the new regulations, qualifying employees are protected from the moment they notify their employer of pregnancy or adoption placement, either verbally or in writing. Are protected until 18 months after the birth or adoption placement of the child. Have the right to be offered suitable alternative employment in a redundancy situation. If the company has no suitable roles available, the employee could request that someone else, in another role, be made redundant so they can occupy that role on their return to work. Irregular workers' holiday pay. Since 2020, irregular hour, 0-hour and part-year workers' holiday pay entitlement had to be calculated as an average week's wage, worked out over the preceding 52-week period. Revisions to the Working Time Regulations 1998 have been implemented to help simplify the calculation of holiday entitlement for workers with irregular hours and part-year workers, aiming to ease the process for employers. As from the 1st of April, 2024, employers can calculate holiday entitlement for these groups as an additional salary percentage payment of hours worked. The government have set this rate as 12.07%. Employers must also take into consideration what makes up the employee's normal rate of pay, including other pay elements such as commissions. As from the 1st of April, 2024, there have also been changes to the statutory government payment rates, including the national minimum wage, statutory sick pay, redundancy, maternity, adoption, paternity, shared parental leave, and parental bereavement pay. The most notable alteration in the April 2024 update is the expansion of the national living wage to encompass workers aged 21 and over. Previously restricted to those aged 23 and above, this top-tier rate now extends its reach to include a broader spectrum of the workforce. The new hourly rates are £11.44 for 21 and over, £8.60 for ages 18 to 20, and £6.40 for ages 16 to 17. The new apprentice rate is set at £6.40 per hour, aligning it with the rate for workers aged 16 to 17. As already indicated, the easiest way to ensure that you stay on the right side of the changing legislation is to make sure you have in place the correct policies and handbooks to protect your business. Let Key HR take care of all your HR compliance needs. Contact us today for a free consultation.